$405. That is how much I was ordered to pay for running a red light, captured via camera in September 2021. The license plates were clearly visible. There was no cop present, so no human error. They had me pretty much dead to rights. But I decided I would not pay the fine. 2 years later, exactly 2 years later actually, I received in the mail this letter. It's addressed to the Alberta Court of Justice. It's from the Alberta Crown Prosecution Service, and I'm CC'd in it, and I'm going to read this to you. Pursuant to Section 579 of the Criminal Code, you are hereby directed by counsel instructed by the Attorney General for that purpose to make an entry on the record that the proceedings against the above-named accused, me, on the above-named charges are stayed. What does that mean? That means that the charges were thrown out and I beat the ticket. So how did I fight and beat this ticket? Well, that's what I'm going to tell you about today. Okay, so how did I beat this ticket? Well, as I said earlier, the process took about 2 years, and that's pretty important. When I first received the fine, the consensus among my family, my friends, and myself was I had no chance in hell of fighting this. They had me on camera, and they had my car on camera, and in Alberta, it doesn't matter if they captured you or your friend or your wife or your dad. It doesn't matter. As long as your car was captured on camera, the license plates are clear, you are responsible for paying the fine. You are liable. That's just how it works. Furthermore to that, there was no cop present. This was done automatically, so there's no human error. I couldn't argue that. When I did look into the camera, it seemed like the camera was calibrated fine, so it's not like I could claim improper calibration, have the case thrown out that way. No, it seemed like they had me, and there wasn't very much I could do. Regardless, I decided to plead not guilty. When I pleaded not guilty, I was given a court date, January 2022. That was right around the time of the COVID lockdowns. So what happened is my court date was delayed until June of 2023, over a year later. A year passed by, and I hadn't really figured out what to do with this ticket until I started looking into the Canadian Charter of Rights and Freedoms. And what I had found and decided to argue that one of my rights had been infringed upon, or at least one of my rights had been infringed upon and violated. And that was the right to a fair and speedy trial. Fair is one thing, but speedy I want to focus on here. To get into speedy, we need to understand precedent. So in 2016, there was a precedent set by the case R.V. Jordan. In R.V. Jordan, long story short, basically they said that anything over 18 months in provincial court would be unreasonable, as long as the delays were not caused by the accused, myself, or external circumstances. So, for example, a natural disaster, or in this case, COVID. My case then became completely about arguing that the courts took too long, way more than 18 months, and the COVID delays did not actually move the total delay below the 18-month threshold. So now here comes the tricky part. Okay, it turns out you can't actually just go up on the stand and argue a chartered argument. That's not how it works. Instead, since it is a Canadian Charter of Rights and Freedoms argument, you need to create a lot of legal documentation. So this entire packet here of indexes and notice of charter and affidavits and schedules and exhibits with evidence, I had to create all of this, figure it out by myself, because apparently unless you are specialized in this area of law, the lawyers don't really know anything about it, and it was a lot of work. So I cross-referenced ChatGPT, I cross-referenced things I found online, I cross-referenced information I had from other people, and put it all together to finally make this chartered argument. And then from there, what I had to do is I had to file it with the courts. So I went to court on my court date. They told me I needed to file it. I filed it. They gave me a new court date. I also had to serve this to the prosecutor in charge of my case, the Attorney General of Alberta, and the Attorney General of Canada. And figuring out how to serve is a process in itself. Basically, I just did it by registered mail. But anyway, once I had all of that done, all of this work done, I was ready for my next court date. I was going to present my case to the judge, and then from there, let the chips fall where they may. So I'm gonna read to you what I was going to present in court had the charges not been withdrawn. According to the Canadian Charter of Rights and Freedoms, specifically Section 11B, every individual has the unquestionable right to a fair and speedy trial. In 2016, in the landmark case R.V. Jordan, the Supreme Court of Canada unequivocally established the presumptive ceiling for provincial matters at no more than 18 months. Notably, this 18-month period expressly excludes any delays caused by the defendant or external circumstances. Turning to the specifics of my case, the offense date was September 6, 2021, as clearly demonstrated by Exhibit A. My first court appearance was not until June 30th, 2023, as evidenced by Exhibit B. In R.V. Omerzada, 2003, the court ruled that the time from the offense date to the time of the trial ought to be considered as the time the accused waited for their trial. In my case, there was a total of 21 months and 24 days between my first court appearance and the date of the offense. To emphasize, this comprises 662 days total. And crucially, none of these delays were attributable to any actions or choices on my part. The entirety of these delays falls squarely on the court system, and although some external circumstances influence these delays, they cannot serve as an excuse for the extended timeline. External circumstances, as per legal precedent, are not counted towards the total of 18 months. The COVID-19 pandemic can be characterized as a compelling external circumstance well beyond the court's control. To assess this, let's examine the precise dates of key closures. November 24th, 2021, high schools were closed. December 8th, 2021, a hard lockdown was imposed. January 14th, 2022, businesses gradually reopened. March 1st, 2022, gyms and libraries resumed operations. Exhibit F clearly illustrates that traffic court was closed between January 4th, 2022 and February 18th, 2022 for in-person appearances, totaling 14 days. When we subtract this period from the overall delay, we find a delay of 21 months and 10 days. Notably, during this period, the courts continued their operations by ordering appearances through audio and video conferences. Exhibit H validates this, as it highlights an order pronounced on January 4th, 2022, explicitly stating the court's ability to summon the accused via audio or video conference. Consequently, it is clear that the courts remained reasonably functional during the COVID-19 pandemic, and this functionality must be factored in when calculating the external delay attributable to the pandemic. To further examine the external delays, we can scrutinize the duration of the hard lockdowns. When nearly everything was closed, extending from December 8th to January 14th, lasting 1 month and 7 days, when we subtract this period from the total delay between the offense date and the first court appearance, 21 months and 24 days, it becomes evident that we still surpass the 18-month threshold. 20 months and 17 days. Even if we consider the entire softer lockdown period spanning from the closure of high schools on November 24th to the reopening of gyms and libraries on March 1st, encompassing 3 months and 6 days, the total delay remains in excess of 18 months. 18 months and 18 days, to be precise. It is vital to underscore that the courts were functional for the majority of this softer lockdown period. However, there is one more critical aspect to my case that demands attention: disclosure. R.V. Stinchcombe unequivocally established that the obligation to disclose will be triggered by a request by or on behalf of the accused. Such a request may be made at any time after the charge. My formal request for disclosure, documented as Exhibit C, was submitted on February 7th, 2022 at 3:45 p.m. as of today. 2022 at 3:45 p.m. As of today, I have not received the requested disclosure. The substantial delay in receiving crucial information has severely hampered my ability to adequately prepare my defense. Moreover, the affidavit of service for the disclosure as presented in Exhibit D indicates an incorrect mailing address, specifically blah, blah, blah. I'm not giving you the address. An address entirely unrelated to me. I received the envelope containing the affidavit opened and at a later date, which to my knowledge is indicative of an incomplete service. Furthermore, Exhibit E displays the correct address as blah, 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 confirming that the court had the accurate address on record. This discrepancy highlights a clear error in the mailing process, leading to the delivery of essential documents to the wrong location and is indicative of improper, incomplete service. As a remedy for the violations of my rights under Section 11B and Section 7 of the Charter, I request a stay of proceedings. Thank you for hearing my case. I appreciate your consideration for my case, and I earnestly look forward to a just decision in this matter. Okay, so that was basically the TLDR of that long legal filing. So that's it. That's how I won my case, and I hope it was of some use to you. I learned a lot during this process, and I feel good in doing something that generally people would say you can't do. And I think one of the most important takeaways of this for me is that if I had decided not to fight this based on the fact that there was no evidence in my favor that I could fight this, I would have been right. I would have paid the fine, and there would have been no evidence. However, because I did decide to fight it in the presence of no evidence, evidence was created in the form of a delay in a court date, which allowed me to actually argue my case. So what that tells me is that even though reasons might not be readily available to do something, might as well give it a try. What's the worst that can happen? You end up paying the fine that you are going to pay anyway, but you also open up the opportunity for something to go your way. Okay, I hope you enjoyed, and I will see you guys next time. Easy, 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 easy.